Welcome everyone to ConMaciel's Labor and Employment webinar series. Today, Lindsay DeSalvo and I will be talking about drug testing issues, and specifically we'll get into marijuana and how that relates to both the ADA and OSHA. Hopefully a lot of you have heard me on some of our presentations earlier this year or some other years. For those of you that don't know me, my name is Jordan Schwartz. I've been a partner at ConMaciel Carey for 4 years now. We just celebrated our 4-year anniversary as a firm. And what I do here is basically all aspects of labor and employment defense. I defend employers in litigation at both the federal and state levels. Specifically, I do a lot of ADA and FLSA, also deal with Title VII and FMLA, and I counsel employers on compliance with federal and state law, including various issues relating to hiring, discipline, internal investigations, and termination of employment. I'll also let Lindsay introduce herself here.
Good afternoon, everyone. My name is Lindsay DeSalvo, and I'm an associate at ConMaciel Carey, and I'm an associate in both the labor and employment and the workplace safety practices. So similar to Jordan, I also handle all aspects of defense for our employers, including issues that arise under the ADA and related to drug testing. I also assist with revising and updating policies on these types of issues in both the labor and employment and the OSHA context, and also represent employers in the OSHA context related to enforcement actions.
Okay, great. So we're gonna get started here. Hopefully you all saw my note on the bottom left-hand portion of the screen. Your lines are all muted, but there's a box where you feel free to type your questions, and either Lindsay or I will try to address them either in the middle of the presentation, or sometimes we don't see them until a little later, but when we do see them, even if it's at the end of the presentation, we will address your questions. But the agenda for today is I'm going to spend at least half the presentation, and possibly even a little more than half the presentation, on these first two issues. One, just giving you really a general overview of both federal and state laws related to drug testing and what you need to know as an employer. And I'll also talk about what the effect of marijuana legislation, which is now in more than half the states, how that affects you as an employer, and kind of give you some best practices to address the issues dealing with marijuana. And then Lindsay will talk about various drug testing restrictions from an OSHA standpoint, and in particular as it relates to injury reporting and anti-retaliation rule. So to start right away, as an employer, when I was coming up with these slides, I figured from your perspective, what you want to know is, as an employer, can you legally require current employees to take drug tests? And a separate but related issue is, can you require job applicants to take drug tests? And you know, the laws love to confuse us, and there's typically different laws between current employees and applicants. And then the third prong is, if we can, how can we ensure that we require these drug tests without running afoul of the law? And first, as background, so you know, federally, the federal law doesn't really have much to say about this, at least as it relates to drug testing in the private sector. A few years ago, the U.S. Supreme Court ruled that while drug testing does potentially infringe on an employee's privacy, it can be necessary in order to protect the health and safety of others. So essentially they kind of punted on the issue and said, well, there might be some problems with it, but we're not going to rule on it from a federal perspective. So while the federal law does have a few specific regulations for the Department of Transportation and the Department of Defense, for most of you on this call, we're dealing with private employers. There's not too much you need to know about federal law. There is something that you may have heard of called the Drug-Free Workplace Act. And what that does from a federal law perspective is it imposes certain requirements specifically dealing with employee education and some notice requirements on companies, but that is only for companies, that's only for government contractors, which means companies that do business with the government. And even that is not really requiring or authorizing drug testing. It's just imposing these educational and notice requirements. So that's just really important to know if you are a government contractor. But if not, that's really not something you need to worry about. What you need to worry about as a private employer when you're thinking about drug testing, and this is one of the most important slides I think I have, are the general legal concerns that end up being more so state law, although there's kind of a nexus between federal law and state law. For example, one of the concerns, if you're deciding to drug test or not, is a concern about discrimination, and that an employee can bring such a claim for discrimination under either, or most likely both, federal and state law. So you need to be 100% sure that if you are deciding to test for drugs, you're not singling out a certain group of employees for drug testing, either by race, age, gender, or any other protected characteristic. What you might want to do is single out a specific job. For example, everyone who is a driver for your company, that you can test for drugs, but certainly you're not going to test only females or only males. And at this point, I'm not even going to bring up discrimination claims based on disability, because I have a whole separate section about that, since that is such an important and the most prevalent discrimination claim when we're dealing with drug testing concerns. But the discrimination claims, you just need to be careful from both a federal and state level. Aside from that, other claims that you need to be careful of, as you see in this picture, is just violation of laws and procedures. And that's more of a state issue. So let's say your state gives you the right to engage in drug testing, that still, you're not fully, let's say, off the hook. You still need to follow your state's requirements for what to do to actually perform drug testing properly and lawfully. For example, in Maryland, where I happen to live, an employee can bring a legal challenge against an employer who did not have a legitimate business reason to test or did not provide documents that were provided following a positive test result. Another common claim in drug testing is an invasion of privacy. Even as an employer, if you're allowed to test for drugs, the way you conduct the drug test could lead you susceptible to an invasion of privacy claim. Potentially if you require an employee to disrobe in an improper way or provide a urine sample in front of others, those are just things you need to be careful about. And finally, an employee might also have a valid claim for a defamation if you publicize the test result, and especially if it's a false positive. So these are just various legal concerns you need to be aware of, in addition to the concerns whether or not drug testing is lawful in your state generally. So as a rule of thumb, employers generally have the right to test for drugs under your state law, unless there is a restriction otherwise. And I'm not going to go through all 50 states right now, but I'll just give you a synopsis of a few states kind of around the D.C. area, just so you can kind of get a sense of what the law is, in case you happen to be in those states, or just to kind of show you what's indicative of the various state law. By the way, someone asked a question about whether these slides will be made available after the webinar, and they certainly will. We will distribute them to everyone who is on this call. Many states have enacted provisions imposing some type of drug testing restrictions. For example, some states authorize drug testing for employees in safety-sensitive positions. Some states limit drug testing only if you have reasonable suspicion or a probable cause situation. Others impose restrictions on public sector employees, but not on private companies. And as I mentioned earlier, many, if not all, mandate specific methods for handling specimens and the use of test results. And since my firm here is in D.C., I wanted to tell you that D.C. is probably the most common in that it does not address drug testing in the law only addresses public employers. It does not address private employers. So that means you can decide whatever you want to do since the state doesn't prohibit or restrict drug testing, obviously unless you're violating the other legal provisions that I described earlier. And again, this is probably the majority of states. But there's always nuances. For example, what D.C. does do is it prohibits employers from requiring applicants to submit to a drug test for marijuana until after a conditional offer of employment has been made. It's really interesting that this was came into legislation about 2 years ago, and even if the position is a safety-sensitive position or it's dealing with security clearance, you still cannot be tested for marijuana as an applicant until the employer has extended a conditional offer of employment. Once a conditional offer has been extended, then you can test. So it really just pushes back the testing process. But D.C. is not the only state to have this law, so if you're in a different state, you want to make sure that no such law exists for you. Virginia is similar in that it also does not address drug testing in private employment other than government contractors. So you can decide what you would like to do either way, but in Virginia, you need to, whatever policy you decide on, it must be in writing and it must be disseminated to all employees with an acknowledgement form. So Virginia is very strict on a clearly written alcohol and drug testing policy. Virginia also has certain requirements dealing with workers' compensation. I included West Virginia because I feel like that's a pretty interesting one. The statutes don't address drug testing, but there's a few cases. The West Virginia Supreme Court found that an employee's right to privacy may be paramount, so unless you have good faith suspicion or a safety issue, you cannot test for drugs. However, there is also another case in West Virginia saying a job applicant is not entitled to the same privacy that an employee has, so you can test for job applicants. So again, this is just to kind of give you a sense of how different the law is in every state and how different it is between employees and applicants. So going forward, if you have questions about your particular state, you can always reach out to me or Lindsay or someone else at our firm, and we'd be happy to assist you to make sure you have a drug testing program that is compliant with your state law. Also, if you are unionized, you really need to make sure that drug testing procedures are set forth in your collective bargaining agreement, so there is not a claim that you did not engage in a duty to bargain over this specific issue. That's a very hot button issue with unions. So that's really the general quick overview I wanted to give on drug testing as the federal and state law pertains to it. But now, before moving on to marijuana, which is what most people on these webinars and presentations get the most excited about, I wanted to spend just a few minutes talking specifically about the ADA, since that is where most of any legal issues and challenges that you will have will come about in a drug testing issue. So the ADA is interesting. The ADA provides that a person using illegal drugs is not a qualified individual with a disability and is thus not protected by the statute. Further, testing for illegal drug use is not considered a medical examination. So given that the ADA does have a lot of restrictions regarding medical examinations, it does not restrict when an employer can test for the use of illegal drugs, since that is not considered a medical examination. So for the most part, drug testing is allowed under the ADA because of the fact that the ADA does not consider drug use to be a disability. Under the ADA, alcoholism is a disability in many circumstances, and former drug use, a recovered drug user, may be protected disabilities. But current drug use is not considered a disability under the ADA. Nonetheless, disability discrimination is by far the most significant legal risk in deciding whether or not to engage in drug testing, because if an employee is fired or if an applicant is denied because of a positive drug test, and if his or her medication was legally prescribed for disability, that is where you could be liable. So, in other words, if you test and the result comes back for an illegal substance that was not prescribed, you're in the clear. But if there's any sort of ambiguity and the medication was legally prescribed and there's an adverse employment action as a result, that's where you can really get into trouble under the law. And you have to keep in mind that some prescribed medications do turn up on drug tests, and some drugs that would otherwise be illegal may be legitimately prescribed for certain conditions. And of course, we'll get into marijuana specifically in a few minutes. But generally, if there is an ADA concern, and hopefully many of you on this call know this already, there's what's called a reasonable accommodation obligation under the ADA, and that applies both at the application process, the hiring process, and during employment. And people think of this as relating more to someone, let's say, in a wheelchair or on crutches, but it also relates to someone who may be taking medication or otherwise is dealing with these issues relating to drug tests. And in this case, employers must make reasonable accommodations to allow individuals with disabilities to apply for and be considered for jobs, so long as the accommodation does not cause undue hardships. And again, that includes accommodations in connection with even with pre-employment drug testing. And there's just a few quick lawsuits I wanted to kind of scare you a little bit, but kind of show you where some of these cases end up going. A few years back, there was a case against Kmart where the applicant had a kidney disease and was undergoing dialysis, and he expressed his willingness to take a different type of drug test. The Kmart required a urine analysis, and the applicant said, I can't do that because of my disability. I'll do a hair test or I'll do a blood test. And Kmart denied this requested accommodation, said it was an undue burden, and insisted that their policy was that all new hires complete the standard urine test provided at its facility. And then when the applicant couldn't do it, it revoked the job offer. And the court said that this was not reasonable under the ADA. They did not grant an accommodation that they otherwise could have. And as a result, they were forced to pay a six-figure settlement. There was an extremely similar case out of Walmart. That the exact same thing. The applicant had a medical issue that prevented her from taking a urine test, and Walmart withdrew the offer instead of engaging in the interactive process and coming up with another reasonable accommodation. And Walmart also was forced to settle this case for a lot of money. So that's kind of the nuts and bolts of, let's say, quote-unquote, regular drug testing issues and how it relates to the ADA and other, state and federal laws. But this all just gets a little convoluted and tricky when we talk about marijuana, because, as most of you know, marijuana is so tricky because it's legal in a lot of states, but it's still considered illegal under federal law, and that's really where the trouble arises. So at this point, and this law changes almost every day, but approximately 30 states and the District of Columbia have legalized marijuana use, at least for some medical conditions. And there's more states that are upcoming that in the next year or two will be legalizing marijuana in some way, shape, or form. And you may be able to see, I hope you can see on this slide, I have highlighted the states where not only is medical marijuana legal, but also recreational marijuana. But I'll get into that in a few minutes. But first, I'm just going to talk briefly about medical marijuana. So even medical marijuana, again, we're not talking about recreational marijuana yet, even medical marijuana remains illegal under federal law, even though these 30 or so states have legalized some form of medical marijuana use. And, this patchwork of laws creates uncertainties for you as an employer when you're attempting to implement and apply your workplace policies across state lines. Given that marijuana is lawful, if it is in your state, then even more so you need to consider the ADA. And you also need to consider if there's other state laws that might require an accommodation for compliance with drug testing procedures. Despite these laws in your state, as we've discussed, you still are free to set your own drug policies and to discipline or terminate employees who violate these policies. But with marijuana, you need to be careful, because let's say you want to fire someone, but it turns out he or she is a medical marijuana registration card holder. You need to figure out, is that a protected class in the state in which you're in, and can you potentially not fire that individual? And one example of this is a case that arose in Rhode Island recently. And in this case, a grad student who was a paid intern, she received an offer. Then the company found out she was a registered medical marijuana card holder, and then the company rescinded the offer and said, they did not want her working at the company anymore. And unfortunately for the company, Rhode Island has a law that's a specific anti-discrimination provision based on card holder status. And under that law, an employer may not refuse to employ or penalize a person solely for his or her status as a card holder. So this is an interesting law. It's a little different than disability discrimination. It is just discrimination based on your status as something, in this case, a cardholder. And Rhode Island is not the only state to have this law. I believe Arizona has this law, Delaware has this law, Connecticut has a form of this law, and Illinois, Maine, and Minnesota all have similar laws to this. When you get my, these slides, likely tomorrow, here's another slide that just explains this case in a little more detail. It's called Callahan versus Darlington Fabrics Corporation. And the main takeaway is Rhode Island law does permit employers to discipline employees with a marijuana card only if they come to work under the influence in a manner that affects their job performance. Otherwise, no adverse action can be taken. Another interesting case, and it's really, it's something. A lot of people would have expected a lot of these cases in the last few years to be coming out of Colorado or Oregon or Nevada or even California, but a lot of the law is developing in what's called the First Circuit, so Connecticut, Rhode Island, Massachusetts. And this case, called Barbuto versus Advantage Sales and Marketing, the plaintiff used medical marijuana at her own home to treat her Crohn's disease, and she subsequently took a drug test. The drug test came back positive, and she was fired from a marketing position after failing the drug test. And, not surprisingly, the company said, sorry, we follow federal law. It's, you're taking an illegal drug. We have no choice but to terminate you. The plaintiff, not surprisingly, claimed she was being discriminated against based on her disability, based on her Crohn's disease, in violation of the state law and also in violation of marijuana law. And initially, a trial judge agreed with the company and said it's illegal under federal law, but the Massachusetts Supreme Court unanimously reversed and relied on language in the state medical marijuana law that prohibited the denial of any right or privilege on the basis of medical marijuana use. And as a result, the court held that since the plaintiff was disabled, the company's claim that she was using an illegal drug was not a valid argument. And the court also said that it doesn't even matter that there's no duty to accommodate the on-site use of medical marijuana as long as this person was protected under the state statute and the legislator had intended that off-site marijuana use did not inhibit an individual's rights when they were on-site. So unless a company could show that the use of marijuana by an employee somehow violated the employer's contractual or statutory obligation and jeopardized its ability to conduct business, it would not be able to legitimately assert and prove an undue hardship defense. And I thought it was really interesting. There's just one quote I printed out from the court case that said, where a handicapped employee needs medication to alleviate or manage the medical condition that renders her handicapped, and the employer fires her because company policy prohibits the use of this medication, the law does not ignore the fact that the policy resulted in a person being denied employment because of her handicap. In other words, kind of a prima facie case of disability discrimination, that the court just ruled that she was fired because of her disability, and obviously that is something that as an employer you do not want to be doing. I'm just seeing a few more questions about how we get copies of the slides. Either Lindsay or myself or potentially someone else from our office tomorrow will send you all copies of these slides so you have them going forward. So today you can just listen to Lindsay and me and hear what we're saying and not have to worry about copying down the slides or anything of that nature. Okay, so moving on for a minute from medical marijuana and moving towards recreational marijuana, which gets even more complex in some situations. You know, the first 4 states to legalize recreational marijuana were Colorado, Washington, Oregon, and Alaska. But now California, Nevada, Massachusetts, D.C., Maine, Vermont have all legalized it from a recreational perspective. For the most part, what this does is these laws decriminalize the use of marijuana for recreational purposes. In that way, it's almost treated and regulated similarly to alcohol use. So if someone is caught using marijuana, they're not subject to any sort of criminal charges. But what none of these laws really create specific employee rights or even clarify employer obligations. So the fact that marijuana use, recreational marijuana use, is potentially lawful in the state in which you operate doesn't 100% mean you cannot discipline someone for marijuana use, and it doesn't really create some contract of employment that you need to guarantee employment to someone with marijuana. And I'll explain that more here. The question that comes up is, you know, I get this all the time, is it lawful for me as an employer to terminate an employee who tests positive for marijuana? And there's a lot of factors here. Depends on, the main thing is it depends on the state in which you're located. Does your state permit recreational marijuana? Does it permit medical marijuana? And does it have a statute that protects discrimination based on being a registered card holder? And all 3 of those factors are necessary to fully analyze your claim. But for the purposes of this presentation, and I'm just kind of giving you a general overview, the answer to the question, and remember the question was, is it lawful to terminate an employee who tests positive for marijuana? Generally, still, in most states, the answer is yes, especially if the marijuana is used on your premises or if there's any sort of effects of marijuana use, some sort of intoxication on your premises. That I don't want to say 100%, but very, very close to 100% would support your ability to terminate the employee. What is trickier, we've talked about this a little bit, is what do you do when an employee tests positive for marijuana, but you haven't, if it wasn't you on your company site and you didn't see any ill effects of that on the job? And I've phrased it here. Can you discipline an employee for off hours and off-site use? And the answer will be pretty much no when it's pursuant to a valid prescription in marijuana states, and pretty much yes for off hours and off-site recreational use in recreational states. But again, that is just a general overview, and more facts would be necessary to actually analyze that claim. And where this also comes into play a lot is lawful off-duty activities. Some states, like Colorado, have rules that prevent employers from taking action against you for conducting activities that you performed while you were off-duty. These rules were typically brought into place to protect political activism. But if you take an action against an employee with a positive drug test, it's possible you can run into an issue with a statute that prohibits you from taking adverse actions for lawful off-duty activities. So you need to be careful and figure out if your state has such a law when you're potentially disciplining employees for off-duty marijuana use. This did end up being an issue in Colorado 2 years ago, and the main issue in the court was, did an employer act lawfully when it terminated the employment of a quadriplegic who suffered from debilitating muscle spasms and possessed a valid medical marijuana prescription? The plaintiff claimed that he was not in a hazardous position. He wasn't really even in an executive position that would require decision-making, and he was never under the influence of drugs on the time he was working on company premises. He also claimed that the company knew of his status as a medical marijuana patient, and that Colorado, since it had a lawful off-duty conduct rule, the state statute should have prevented him from being terminated. The court, however, found that marijuana usage could not be considered a lawful off-duty activity since the federal statute still characterizes marijuana as an illegal controlled substance. And as a result, the Colorado Supreme Court ruled for the employer and upheld the termination. I'm not convinced in 2018 or going on 2019 a court would rule the same way. But, as of now, at least in Colorado, this is the law. So the lawful off-duty conduct does not appear to be a successful argument for an employee in Colorado. But that does not mean it wouldn't be a successful argument for an employer in an employee in a different state. So for that reason, I think this third bullet point is most important here, that as an employer, you should, if you have a blanket ban on marijuana use, you may want to reassess it. I'm not saying you need to change it, but you want to really take a good look at that and make sure that's what you want to be doing. And the practical aspects to consider while doing that are, will a zero-tolerance policy on marijuana use, will that reduce your pool of qualified candidates to an unacceptable level? Will failing to test for marijuana increase work injuries or absenteeism? Will treating marijuana differently than any other illegal drugs create problems in your workforce and in your workplace? Those are the practical aspects you need to consider, because zero-tolerance policies in general, more employers are leaning towards more flexibility and softening zero-tolerance drug policies, particularly for jobs where safety is not an essential function. I have also talked to many employers who are not softening their policies, but as a general rule, more are than aren't. State laws allowing marijuana use are complicating recruiters' efforts to find drug-free employees, and low unemployment and increasing use of drugs are narrowing the pool of qualified workers in many regions and industries. So if you decide to relax your zero-tolerance policy, attempt to get buy-in from company leadership that supports the move and how to deal with the consequences. Consider your risk tolerance for the workforce and risk tolerance for litigation. And as I mentioned earlier, no changes in employer policies or practices really should ever excuse an employee who is impaired while working, especially if that employee is in a safety-sensitive position. And speaking of safety-sensitive positions, I'll now turn it over to Lindsay to talk more about OSHA issues.
Great. Thank you, Jordan. So just as we have requirements under certain employment laws for drug testing, OSHA also does have some requirements for drug testing. And actually, those requirements were established by a 2016 rule that's referred to as the Rule to Improve Tracking of Workplace Injuries and Illnesses, as you can see on this slide, the title right there. The rule requires electronic submission of injury and illness data, but in the course of promulgating and then implementing the rule, drug testing requirements did end up getting pulled into it. So to start, I'll just do a little bit of background on this rule and sort of the main objectives and requirements of the rule. The rule was promulgated on May 12, 2016, and it was promulgated for the primary purpose of creating an electronic system so that OSHA could obtain and track information on recordable injuries and illnesses in employer workplaces. In that regard, the rule as promulgated requires that individual employer establishments with 250 or more employees for whom the employer is responsible for supervising those employees, that those establishments have to submit their 300 logs, data from their 301 incident reports, and data from their 300A annual summaries. However, as many of you may know, particularly if you have participated in some of our prior OSHA webinars, OSHA has only required so far that these establishments of 250 or more employees submit their 300A data in the 2017 and 2018 submission years. Additionally, as you may have heard, OSHA has proposed to revise this rule so that it mandates these establishments of 250 or more employees only have to submit 300A data going forward. So that rule proposed rule has just been promulgated. OSHA is actually currently accepting comments on that provision as well as a couple other parts of the proposed rule right now. But so OSHA is trying to transition so that it is only collecting 300A data. And then additionally, certain individual establishments with 20 to 249 employees in industries that are established as high hazard industries, and that list is included in the rule, the industries that are included in that list. They have to submit OSHA data annually, but just the 300A annual summaries. So to determine the applicable employee count and decide whether either of these provisions, so basically the same at this point in the implementation, whether they actually apply, it's an establishment by establishment consideration, and employers have to look at the peak employment of workers who it supervises throughout the calendar year for each of those separate physical locations where business is conducted or services or operations are performed. So this information should be submitted by the employer electronically through a secure website that OSHA has generated and is open on its site and has been open for both the 2017 and 2018 submission years. That data can be submitted by either a representative from the employer's headquarters, or can be submitted by someone that is present at each individual establishment. The current rule does state that data submitted to OSHA pursuant to this rule will be made public. However, such a step has not yet been taken by OSHA. Interestingly, not too long after OSHA set up its website and started providing FAQs, the FAQs related to publishing of data were removed from OSHA's website, but they haven't really made an explicit statement about what's going to be done about publishing data going forward. There is another way that individuals can obtain that data once it's collected by OSHA, which is through a FOIA request. So in that way, some of this data may be made public, but right now OSHA is not currently publicizing it on its website. And then the problem with publishing data is the negative impact that it could have on employers. Even if the data is limited to information from the 300A summary, that injury and illness information is being provided without any context or understanding of what the data means, where it comes from, how these injuries and illnesses actually occurred. So access to this data could still hurt relationships with prospective employees who might see an injury rate and have a certain perception of an employer, or with potential clients, as well as being used in a civil lawsuit or for union organizing purposes. A union could still point to the total injuries and illnesses in a given year that's represented through a 300-day summary to say that their presence is necessary to create a safer workplace for employees, even if it might be the case that many of those injuries were not caused by workplace hazards. So as a result, employers and employees might still want to avoid that perception of an unsafe work environment, be very concerned about having this data publicized somewhere along the way, and so this could actually result in underreporting. Although injury and illness tracking was the primary motivator in OSHA developing and promulgating this rule, it has been used, and OSHA has, in its implementation, decided to implement the rule in a way that includes anti-retaliation and, as we'll get to, drug testing. These provisions were not originally included in the rulemaking, but OSHA was permitted to reopen the record for this regulation so that it could respond to multiple complaints it had received during the rulemaking process that the rule would lead to underreporting and underrecording of injuries and illnesses due to the potential that this information could become public. As a result, OSHA published a supplemental notice of proposed rulemaking that went even further in the requirements it established, instead of addressing the issues that the current rule raised, or that the current rule had and were raised by industry during the rulemaking process. And this supplemental notice focused on employers' practices that could allegedly chill injury reporting and included elements of an employer's programs and practices that might discourage reporting, that OSHA perceived would discourage reporting, and also those that they perceive to be retaliatory against employees who do report injuries and illnesses. So this slide shows the overarching explicit requirements related to the anti-retaliation provisions of the current rule. As to the first and second points, the employer is required to inform employees of their right to report injuries and illnesses, and that such reporting will not result in discrimination or retaliation against the employee. One way that an employer can accomplish both of these first two requirements is by posting the workers' rights poster that can be found on OSHA's website, because it includes a statement to that effect. Employers must also revise injury reporting policies to remove those practices that OSHA has deemed to be unreasonable and related to reporting and the impact that the policies and practices could have on an employee's willingness to report. And this is actually where the drug testing component comes in. As you may be aware, prior to this rule, OSHA did have 11C of the OSHA Act, which prohibited retaliation against employees and did allow OSHA to take some action if an employee were to claim that they have been retaliated against. So although 11C already provided this protection against retaliation, these new anti-retaliation provisions related to record keeping and reporting allow OSHA to cite an employer for basically the exact same thing, but in the context of an enforcement action as opposed to a separate proceeding under 11C of the OSHA Act. So as related to drug testing, the electronic data submission rule has been used to somewhat limit how, as well as when, an employer can drug test an employee when a recordable injury or illness has occurred. Specifically, OSHA has asserted that post-incident drug testing may dissuade a reasonable employee from reporting a work-related injury because it would result in an invasion of the employee's privacy. So based on that assessment, OSHA determined that limiting drug testing would, as a result, cause more employees to report injuries or illnesses without fear of being retaliated against or disciplined. So the key point here is that drug testing cannot be used as a form of discipline or as retaliation for reporting an injury. In other words, the rule does not prohibit drug testing, but it does prohibit the use of drug testing or the threat of drug testing to dissuade employees from reporting an injury or an illness. So in accordance with this goal, OSHA has explained that a blanket post-injury drug testing policy would be impermissible because this would mean that employees are drug tested no matter the circumstances or the type of incident that has occurred. And OSHA has determined that that is impermissible, and it would definitely dissuade employees from reporting injuries or illnesses. For example, a policy that would require drug testing of an employee who reports a bee sting would likely be seen as impermissible under these standards because OSHA would say that the employer cannot show any reasonable basis to think that the effects of drugs or alcohol had any impact on the injury, the bee sting, actually occurring. So this slide shows the types of drug testing that are completely unaffected by the anti-retaliation provisions of the electronic record-keeping rule or data submission rule. The first two have no connection to a specific injury or illness that occurs that may prompt the need for a drug test. So pre-employment drug testing and random drug testing are not affected by these provisions. The second two allow an employer to drug test an employee in any circumstance, including after a workplace accident or an incident, or report the same if the drug test is required by state or federal law, such as the Department of Transportation's mandatory post-accident test, or tests that might be required by the workers' comp insurer to evaluate an incident and determine whether workers' comp can be provided or should be provided. Outside of these circumstances, a post-accident drug test would not be a violation of the electronic record-keeping rule if alcohol or drugs were a likely contributor to the incident and where the test used to determine whether an employee is intoxicated can actually detect the present impairment of the employee at the time of the incident. So in other words, the employer needs to have an objectively reasonable basis to believe that drug or alcohol use was a contributing factor to an accident or an incident that occurs that causes or results in an injury to an employee. OSHA has signaled that there need not be a reasonable suspicion of alcohol or drug use in a specific incident, just that drugs or alcohol are a reasonable cause of the type of incident that has occurred. So to be compliant, there should be a reasonable possibility that drug use by the reporting employee was a contributing factor to the reported incident or injury in order for the employer to actually administer drug testing to the employee. And then this slide shows, based on both the preamble to the rule as well as the guidance that OSHA has given so far, the 4 factors that OSHA will assess to determine the reasonableness and the permissibility of a drug test in light of a workplace incident. So the first one, whether an employer had a reasonable basis to conclude drug use could have contributed to the injury. We just talked about that a little bit. The second is whether other employees involved in the incident were also tested. So if there are other employees involved in an accident or incident who did not report the incident, but were involved in some way and their actions could have also contributed to the incident occurring, they need to be drug tested as well. So it can't be that only the person who is reporting the incident is drug tested, where other employees could have also contributed and thus should also be drug tested as potential causes of the accident or the incident. The third factor is whether there's heightened interest in identifying drug use because it's a high hazard activity or responsibility of the employee. So this factor provides further support that drug testing is legitimate and appropriate if the particular work being performed at the time or the particular duty being performed is high hazard, making a strong drug testing policy and enforcement of that policy even more important and necessary, as it's more likely to result in an injury in that circumstance, and potentially a very serious injury in that circumstance. And then finally, whether a drug test is capable of measuring impairment at the time the injury occurred. So if the drug test that is used would not actually assess impairment at the time of the accident, OSHA would view this as more of a form of discipline for reporting, or retaliation for reporting, than a useful safety measure to further the welfare of the employees. So here's one example that OSHA has provided to sort of illustrate how these requirements work, how their guidance should be implemented. So where you have a crane accident that injures several employees working nearby the crane, but the crane operator is not injured. In this circumstance, OSHA says the cause of the accident is unknown, but it's reasonably possible that it was triggered by either crane operator error, spotter error, or rigger error. In this case, it would be reasonable to test all employees whose conduct could have caused the accident. So to the extent that they can't determine what actually caused this accident, the most likely people are the crane operator, the spotter, or the rigger, and all of these individuals could legitimately be drug tested to see if intoxication contributed to this accident. It can also test employees if there's a reasonable possibility that drug testing would provide insight into the root cause of the accident, but they do point out that it would be unreasonable to test only an injured employee. And you'll notice in this case, the crane operator was not injured, and this is someone who is very likely to have caused the incident. So you're only testing those who there is a reasonable basis to believe that they contributed to the accident, and thus, if they are intoxicated, that would have an impact on the cause of the accident. So in addition to having a reasonable policy on when to drug test, employers should also have reasonable policies for reporting injuries and disciplining employees for violation of their safety rules. For example, OSHA may cite an employer who requires immediate reporting of an injury because a rule that requires immediate reporting of an injury may not be practical in all circumstances, particularly if the injured employee is the one who is expected to report, as the injury may prevent them from reporting immediately, and it could create an undue burden on the employee, making it less likely for them to report. However, an employer who has a rule that requires employees to report injuries as soon as practicable, OSHA has determined that that is a reasonable rule to maintain because it gives some leeway then to the employee depending on the circumstances. Additionally, an employer can discipline an employee for violating its safety rules if the discipline is consistent and it's not only occurring after an employee reports an injury or illness. Vague safety rules, OSHA has said they will closely scrutinize vague safety rules to ensure that those safety rules are not employed in a manner that would be retaliatory against employees who are reporting injuries or illnesses. And then finally, there are also certain types of incentives prohibited by the anti-retaliation provisions of OSHA's electronic record-keeping rule. I won't go into too much detail on these because I know we're basically at the end of our time here. But just to kind of give an overview of this particular slide, OSHA is mainly concerned about the chilling effect that certain incentives can have on employees' willingness to report injuries and illnesses. In other words, if the incentive would deter an employee from wanting to report or feeling like they can report injuries and illnesses, because they might lose a benefit for themselves or other employees. This is going to be seen as problematic and impermissible under this particular rule. And just to point out briefly, the first, third, and fifth bullet points shown on this slide are safety incentives that are not permissible under OSHA's regulation. Any time that a reward or a bonus is based on injury rates or on there being no injuries at a particular workplace, OSHA views this as not being compliant with its regulations, because those are the types of rules that would likely dissuade an employee from making a report. However, if an incentive is based on compliance with legitimate workplace safety rules, this is going to be something that is permissible under the standards, and you can see a couple examples of that on this slide in both bullet point 2 and bullet point 4. So the data submission and anti-retaliation provisions of the rule have both been challenged in federal district court. Specifically, you see here the anti-retaliation provisions have been challenged in a Texas federal district court. And as support for challenging the anti-retaliation provisions, industry has asserted that OSHA did not show how these anti-retaliation provisions would reduce injuries, nor did OSHA perform the cost-benefit analysis during the rulemaking process for this particular part of the regulation. As a result, industry did seek a preliminary injunction of the rule, and OSHA actually responded that the injunction should be denied because the plaintiffs could not show irreparable harm in this case. The judge did ultimately agree with OSHA's argument, and it denied the preliminary injunction, and thus the rule went into effect back in December 2016. On January 18th, 2017, OSHA, under the Obama administration, filed a motion to dismiss this legal challenge. However, it did end up withdrawing that particular motion under the Trump administration. So the case progressed, but it was stayed because OSHA conveyed that it would be promulgating a notice of proposed rulemaking and revising this particular rule. So in sum, the status of the anti-retaliation elements of this rule, they are in effect. OSHA is actively pursuing violations under these standards, but so far they've only been pursuing citations or violations where there is an aggrieved employee. And as far as we're aware, there have been no citations issued related to the specific drug testing provisions that we focus on today. As to the legal challenge, it was stayed because of OSHA conveying that it intended to file a notice of proposed rulemaking. So it was stayed to see, what that notice and what the proposed rule would entail. However, the notice of proposed rulemaking does not address the anti-retaliation provisions. So it is likely that this challenge will continue, and we'll see where that leads. So that is the conclusion of our presentation. Let me just look here to see if we have any other questions. All right. So if any questions did come up that you didn't get answered today, or if you'd like to follow up with me or Jordan on anything that we had discussed today, please feel free to reach out. Our contact information is provided here. And additionally, if you are seeking advice on particular issues, we do keep our blogs up to date and are posting often, so you can also check out our blogs, and they're both provided here. Thank you very much, and we look forward to future webinars.
Thank you all very much for attending.